Thank you for joining our webinar presented by PRI and Frier Levitt. John, take it away.
Good afternoon, everyone, and thank you for joining. My name is John Morrone. I am one of the managing partners at Frier Levitt. Frier Levitt is a boutique healthcare firm that has over 30 lawyers who just practice healthcare law, and our primary focus is representing providers from solo physician practices to publicly traded companies and every type of healthcare provider in between. We provide a myriad of legal services, from advising on regulatory matters such as Stark, anti-kickback, HIPAA, et cetera, to representing providers before licensing boards, as well as a significant focus on payer relations and pursuing payer contracts and protecting providers against inappropriate recoupments by third-party payers. The topic that I've been asked to speak about today involves physician employment contracts and basically how to get out of them with a minimal amount of drama and problems. So first, before we get to how to get out of a contract, I will speak briefly about the fundamentals of any employment contract. And those are the term, the termination provision, qualifications of the employee, compensation methodology, scheduling of when the physician would be working, other additional benefits, the non-competition and non-solicitation clauses, partnership buy-in provisions, and choice of law and venue, which are strict legal topics. I'm not going to go through all of the elements in great detail, but rather touch upon only those that are most significant to our topic today. So the first thing that we would look at in evaluating a contract that's already been executed, where the physician is seeking to leave that practice or leave that employer and go out on their own or join another practice, or is who is the employer? We have today hospital systems hiring physicians directly in faculty practice type arrangements. We have what's called a captive practice, which is common, and that occurs where a hospital or health system essentially partners with a private practice. And typically the way this is done is that a new practice entity is formed, and the sole shareholder or sole member of that practice would be the medical director of the hospital or some other physician that's in a management role within the hospital, and that is done to kind of secure the loyalty of that physician. And then in a kind of de facto arrangement, the hospital, through the captive practice physician owner, controls the practice. The next is the physician group, which can range essentially from 2 physicians to several hundred physicians, depending on the setting. There are other relationships that can also come into play. Professional services agreements, where a practice or group of physicians enter an agreement with the hospital or health system to provide professional medical services, but aren't employees but independent contractors. There's IPAs, which are independent practice associations, and accountable care organizations. There are many other types of arrangements where physicians may engage with certain entities, such as pharmaceutical manufacturers, ambulatory care facilities, etc. And those may also implicate some of the concerns that we have about departing from a medical practice. Okay, so what is the process for leaving your employment? And today's topic is really should have been named, how to leave the practice with the minimal amount of disruption to your life and your practice and your professional development. So we really look at the employment contract as kind of the prenuptial agreement. That is the document that really defines the relationship between the parties, but also defines how the parties would break up. And that's where things like the term of the agreement come into play, termination provisions, and then how the parties are allowed to perform post-separation. And that's really after the divorce is when things can really get ugly. Very often, there is a tension between the employer and the departed employee. The employer believes that the patients and the referrals that were generated while the physician was an employee belong to them, where the physician takes the position that the physician is the one that has the direct licensee patient relationship, and therefore they own the patients or they own the relationship. And we'll speak about that more in the context of the non-compete. But much of this is also defined in state law, in Board of Medical Examiner rules and health department rules about handling patients. Because at the end of the day, the relationship is one of licensee patient, and there is a public policy interest in preserving that. Where additional complications come in is, for example, in a group practice or in a captive practice or even a hospital-based practice, where there are multiple physicians that may be treating the patient. Where does that patient belong? Who does that patient's medical record belong to? Where does it stay post termination? These are all significant issues. Before you decide to leave any employment, but particularly when it's a physician leaving a practice, whether it be at a hospital or at a group, before you actually take whatever action is necessary to terminate the contract, have the contract reviewed. Speak to your attorney. Hopefully, when you initially signed the contract, you were represented by counsel who should have advised you at that time on what the various provisions of the contract mean, what you were signing on to, what restrictions you were potentially agreeing to, and what terms you were looking to, what terms have you agreed to that can potentially provide the most problems down the line. And know your risks. Really understand when you're departing, what's the risk of competing? What's the risk of contacting patients? And those risks aren't just the employment risks, but your risks as a licensee. We've seen situations where, physicians have a non-compete and simply walk away and ultimately end up being charged by the licensing board for patient abandonment or receiving complaints because patients felt that the physician left and abandoned them. As is frequently the case, The patient has the relationship with the physician. The patient identifies with my doctor. Um, they Many patients don't even know the name of the group practice, and when they go to the hospital and see, and the physician's practice happens to be inside the hospital, that that there's any relationship um, being established with a practice entity at the hospital, they associate with their physician. So there are many risks, and we'll talk about some of them throughout this presentation. So the first thing to really look at is, what is the reason for termination? Is it for cause? Meaning, uh, is there a reason in the contract that created the cause of termination? And which party can act on that termination? So is it that the hospital or the medical practice breached the provision of the contract, failed to um, provide certain services that were agreed to in the contract, failing to compensate appropriately pursuant to the contract? These are all important um, considerations in a termination of an agreement. On the other side is that, is it a termination by the employer um, for some alleged breach by the physician, either um, failure to perform appropriately? Uh, then there's without cause termination. Is it um, that there is a without cause provision in the contract, and the physician employee simply says to the employer, okay, I'm providing you the requisite 60 days notice and I'm leaving? Uh, is it because of disciplinary action? And particularly where there's an affiliation with a hospital, a loss of privileges may come into play. Is it merely a non-renewal, that the contract expired on its own, by its own term? And then lastly, has something occurred to the employer? Has the employer been liquidated? You're an employee of a medical practice. This is a situation that we dealt with fairly recently in at our firm. You had a physician practice where there was a sole shareholder and a number of employed physicians, and the physician owner unfortunately passed away. And in the particular state, as is the case in most jurisdictions, only physicians can own a medical practice. So there was this void created, uh, which again will have a significant effect when we talk about our non-compete and restrictive covenants. Okay, so the probably the most significant issue with the termination of any employer-employee relationship in the physician space is the non-compete or non-competition. And they come in a variety of different forms and different terms, and it's usually something that is heavily negotiated and creates a great deal of controversy between the parties. So some of those restrictions will be a geographic restriction, that the physician agrees that they will not practice medicine within a certain radius of the medical practice or the hospital. Now, these can become quite expansive, so you have to be careful. Is that we've seen contracts that say it's a 5-mile radius from any facility of the employer. So you have hospital systems that can be spread out over an entire state or region or city. Um, Same thing with private practices. We have large private practices that have 20 or 30 offices. So uh, if the non-compete is not artfully crafted, it can reasonably be interpreted that the restriction is 5 miles of any one of those multiple offices. There's also hospital restrictions that require a physician to relinquish their privileges from the hospital that they're currently employed or affiliated with from their practice group. And again, there's also restrictions that say the physician cannot work for any other healthcare system or any other hospital. What are the penalties? Very often, there are liquidated damages provisions that if a physician competes, in addition to injunctive relief, the employer would be entitled to liquidated damages, money damages, and frequently those are calculated based on the prior year's compensation of the physician. The big question is always is how enforceable is a non-compete? Is it reasonable? And what are the reasonableness elements, or how are they taken into consideration? And finally, a concept known as blue penciling, which I will speak about when we talk about the enforceability of the contract, of the non-compete. Non-solicitation is the other restriction that generally goes hand in hand with non-compete. They are kind of looked at similarly and put in contracts next to each other very frequently, but they're two very different things. Non-competition prevents a physician from practicing within a certain geography for a certain period of time, or there are restrictions put on their future behavior and their future practice of medicine. Non-solicitation, on the other hand, restricts a physician's ability to contact their former patient or their current patients. So they can have a geographic restriction, a temporal restriction. We look to state law to say, state law here applies much more broadly than in non-competition, because there are within Board of Pharmacy Board of Medicine and Medical Practice Acts, how a physician-patient relationship is established. What are the duties that a physician has to communicate with their patients? Is a restriction in a contract against public policy? Does it violate an applicable state law? So there are concerns such as that. Again, we'll talk about enforceability and reasonableness. And then against that backdrop, the backdrop of what's in the best interest of the patient and the community interest. And that goes to that same kind of Medical Practice Act, Board of Medical Examiners rules about physician communication with patients. Just because a particular entity says, tries to compel a physician not to communicate with their patients, it very likely may be illegal. Okay, so in the state of New Jersey, in evaluating a non-compete, the most recent decisions, both in federal and state court, applying New Jersey law, take into account several elements. Now, before I go further, I would just caution everyone that giving an example here for the state of New Jersey, the enforceability of non-competition laws, particularly as they apply to physicians, vary wildly from state to state. Some states and those courts have a bias against enforcing physician non-competes. These states and these courts view non-competition within the practice of medicine as being, something to be disfavored, that's unethical, that affects a harm on a patient who is a non-party to a contract by interrupting the physician-patient relationship. So if you just think that the patient knows nothing of these contracts, was not a party to the contract, doesn't know about it when they first established their relationship with their physician, and then to subject the patient to having to find a new physician or disrupt their care is something that courts in many jurisdictions and many legislatures as well have seriously disfavored. But New Jersey, as a practical matter, the courts have not summarily dismissed um, non-competition agreements. And there are some conservative states or conservative courts that take the position that um, the parties had freedom of contract, and within that, the parties agreed to be bound. And absent some very compelling reasons, uh, the courts in those jurisdictions will be um, really loath to reverse a non-compete agreement. So please keep that in mind when you are faced with leaving a practice or leaving employment. That really retain a qualified attorney to look at your contract, someone that knows the applicable laws. Uh, these in discussions of litigation risk, these are very important factors. So I'm going to go through the key elements of what the New Jersey courts consider. First of all, as a threshold matter, New Jersey courts favor enforcing restrictive covenants and try to avoid just wholesale invalidation of those contracts. However, within that judicial philosophy is something called blue penciling. And without getting into very hyper technical legal analysis or legal discussion, is that many courts or the philosophy of freedom of contract is that if two parties agree to a contract and there's no reason to alter that contract, the courts will not interfere with the contract. Basically, the two parties have to live with their agreement, and within that, the courts will not modify the agreement. If they're let me take a step back. They may modify an agreement by striking out provisions, but they won't modify it by amending those provisions. And that's where blue penciling comes in. So, what is an example of this? So, a contract has a restrictive covenant that says physician can't practice in the entire state of New Jersey. And the judge in the case says, well, that's really unreasonable. But rather than striking out the whole non-competition provision, the judge will impose their own estimate or own judgment on what they deem to be reasonable. So they may turn around and this is where the name blue penciling comes from. Take a map and just draw an area with a blue pencil that identifies the restricted area. And this practice is done fairly frequently in the state of New Jersey to convert an unreasonable geographic region to what a judge thinks is reasonable. The judges, although it's considered as part of blue penciling, may also alter the temporal nature of a restrictive covenant, where the restriction may be for 20 years. The judge may modify it to, say, 2 years. So each of these elements are taken into consideration when the court is looking at the validity of a non-competition agreement. And these also generally apply to non-solicitation agreements as well. The next is there a legitimate business interest? So what is an example of that? An example of that is if, and it kind of is hand in hand with blue penciling, but if a physician is employed by a hospital in the very far reaches of a state, and then sets up business, sets up a practice 300 miles away, and the employer seeks to enforce a restrictive covenant, even if it was within the jurisdiction or within the restricted area, the courts will look and say, well, do you really have a legitimate interest that you're trying to protect, or are you just trying to interfere with the physician's ability to practice medicine? So if, and this will come into play, if a hospital draws all of their patients within a 10-mile radius of their hospital, and a physician practices 30 miles away, the hospital really doesn't have a legitimate interest that the physician is going to interfere with their business. Another topic, the example I gave earlier, where a practice is owned by a single physician and the physician passes away, that medical practice no longer has a legitimate business interest to enforce a restrictive covenant, because the entity can no longer practice medicine. So what is it protecting? It's merely interfering with physicians' rights to take care of patients. The next is undue hardship. So even where there's a legitimate business interest, that can be blue penciled or invalidated because it puts an undue burden on the employee. So again, that would occur if a physician or former employee has to move out of state or pick up their family and move a great distance. So just move in general, sell their house and have to travel across the state. That would be a form of undue hardship. The next thing is injury to the public. The courts will review restrictive covenants to determine if enforcing the restriction would cause a public harm. This is, and this was a statement from the Federal Circuit Court. So an example of how this would affect the public is, and there was a case a number of years ago in New Jersey that addressed this, is a physician treated patients at a hospital, was part of a hospital faculty practice, I believe. But the physician had a very unique skill set, and he was essentially the only physician within a very broad geography that could perform the particular procedures. And patients came from a kind of diverse area to see this physician. And the courts determined that if they enforced the restrictive covenant, the physician would have to move out of state. And if the physician would move out of state, there would be no other physician in the state that could perform the particular procedure. So although the hospital had a legitimate business interest, there would have been a significant injury to the public in circumscribing the access of the public to this particular specialty. So here are an overview of, again, this is applicable to the state of New Jersey. And these are generalizations. Restrictive covenants, including non-compete and non-solicitation, are not per se invalid. They are permissible in the state of New Jersey. That if a restrictive covenant has a legitimate business purpose and does not unduly burden the employee and is not injurious to the public, it can and will be enforced. So this is very important. If you have a contract in the state of New Jersey, you need to have an attorney review it against this backdrop, to make sure that if you leave your employment and you want to continue practicing in the geographic area and maintain your practice, these are things to seriously consider. When looking at a restriction, just determine whether it's overly burdensome or not. Depends on the geographic scope, the subject matter, meaning, in this case, the practice of medicine and even the subspecialty, how broad that restriction is, and the length of time that it's enforced. So some examples of breadth and subject matter is that there are very often restrictions that are limited, and it becomes more complicated for a court to tease apart and decide. So what do I mean? So for example, the restriction may not restrict the physician from practicing medicine at all, but may just restrict the physician from, say, performing interventional cardiology procedures at a competing hospital. So the physician would still be free to practice medicine, could still be a clinical cardiologist, could still see the patients that they saw before, but they couldn't perform procedures at a competing hospital. So that's another consideration that the courts may take into consideration when ruling on a restrictive covenant. Protecting the clients and the goodwill is a legitimate business purpose. So what that means is that protecting a hospital system or a medical practice in the state of New Jersey has a legitimate interest in not having their patients or their patient base drawn away, and that it would qualify as a legitimate business interest. So, as mentioned previously, New Jersey law favors enforcement of agreements, and the courts will blue pencil in a manner to mitigate overreaching restrictive covenant agreements, so that the overall contract can be preserved. So just to reiterate, if you're an employer, this is both employer and employee should thoroughly review and negotiate the restrictive covenants, and have them reviewed by an experienced health law attorney, to avoid litigation, to avoid this post-termination conflict. So in all of the previous few slides, as we talk about the restrictive covenant and how it can enforce, and how it can cause problems for both the employer and the employee, is really a litigation issue, and what will occur in litigation. We'll talk more about that in a moment. Oh, there we go. So I was having a little trouble moving the slide. So once you get to the point where you decide that I, as an employee, want out of this arrangement. And we're assuming for this presentation that you would want to get out of the arrangement and continue to practice in the same geography, not move your family, be able to contact your patients and continue a medical practice with your current patient base in the same geography where you are. So what are the steps after, once you kind of have that inkling that you want to get out of the agreement, that you want to terminate your employment, and you listened to this webinar and said, you know what, I think that lawyer, may have a few pearls of wisdom. So, you know what, I'm gonna go hire a lawyer to review this contract for me and let me know what's what. And so now you know what the playing field is, what you're up against. So the first thing is to try and negotiate. Litigation is an expensive thing, and employers very often, will look at a situation and say, you know what, it's not worth trying to hold on to the patients because, they want to go with Dr. Jones anyway, or, the departing physician is the only physician that performs a certain service. So, the practice may say, well, you know what, we're not going to go out and hire another interventionalist or another surgeon or another subspecialist. So there's no reason to get involved in any type of dispute. So we can just move to a very simple separation and release. So that's just a very simple agreement that the parties, agree to go their separate ways, and what the employee is entitled to financially at the end of their contract. So if negotiations doesn't work, the next is to kind of look at and determine whether you want to just go ahead and terminate the agreement. As I mentioned earlier, is that there's different types of termination, but so you would look at the contract and say, hey, was there something that my my employer did, or that's forcing me to leave? Did they not pay me what I was entitled to? Did they not schedule me accordingly, or have they they committed in the contract that I would work in a very in one office in one geography, or in one in one city or in one town, but they're making me run around to 7 different offices, and I never know what I'm going to do tomorrow. There may be grounds for termination. Now, one thing, and again, this webinar is not about drafting a contract, but one point that I would like to make is that any restrictive covenant, anybody that enters into a contract, the restrictive covenant, you're going to agree to it. It should terminate if the agreement, the underlying agreement, is terminated for cause because the employer breached. That is really a minimum, really needs to be in there as a minimum, because basically, and I've seen many of these contracts written poorly, that the employer can breach the agreement, can terminate you, and you have no recourse in that termination, and you have no recourse against the non-compete because your contract wasn't drafted appropriately. But you should always have that provision in there. Okay. Also, depending on state law, is patient notification. That for both the departing physician and the employer have varying responsibilities about notifying patients. And again, this is, who do the patients belong to? Who are the patients going to go with? What about patient choice? There needs to be notification. Some patients may want to stay with the practice. Dr. Jones wasn't that, great after all. I want to just go to another doctor in the practice. Very often, patients are just comfortable with the practice, and they may see multiple physicians, and one physician who believes that it's their patient, leaves. Most states apply a freedom of choice for patients. Then I'm going to skip back to litigation. I can have these out of sequence. The next is hospital bylaws. What do hospital bylaws say about a termination event? Because very often there's separate due process within the hospitals that allow physicians to keep their privileges at their hospital, notwithstanding the requirements of a private employment agreement. So again, the hypothetical here is you have medical group hires a doctor, and that medical group is affiliated but is not owned or operated or otherwise controlled by the hospital, and that physician employee has received credentials and privileges at the hospital, and now they leave that medical practice. Well, the hospital can't just summarily take away that physician's privileges. And we've seen them try and do that. We've seen influential medical practices try and force a hospital to revoke someone's privileges merely because they weren't working with the particular medical practice anymore. That is generally not acceptable. And again, that's something that, knowing your due process rights within the medical staff at a hospital is very, very important. Then the last and most draconian of measures is litigation. And litigation can occur in a variety of different ways and can start in a variety of different ways. One of the many ways, and this is not something that I would necessarily recommend, but there are attorneys that ascribe to this strategy, would be, just leave, open up your practice, and contact your patients, and let the employer come after you. Let the employer make the first move and pursue litigation. Now, very often, and we represent both sides. We represent employers as well as employee physicians. And sometimes our advice is to an employer, hey, you know what? It's not really worth it financially for you to go through the legal fees of opening litigation against a former employee. There may be political issues. There may be appearance issues. You may create ill will by getting into a war with a physician. Generally, the community and folks on the outside looking in are not going to understand restrictive covenants, and it's going to look like, particularly if it's a hospital, hospital systems, very often they are loath to pursue litigation, because from the outside looking in, it's David versus Goliath. You have this, physician who is just trying to practice medicine, and this big bad hospital system with deep pockets that wants to push them around. But understand that if it does come to litigation, that litigation is expensive. The outcomes are uncertain. No matter what I or any other lawyer tells you, we don't have a crystal ball. We can only advise on, what the standards being applied in a particular jurisdiction are, and kind of make a best hypothesis on what would happen or the likely outcome if litigation is pursued. But really, my advice is to truly, avoid litigation at all costs, because again, it is very costly, both financially and emotionally, And also it creates a level of uncertainty. If you open a practice and you begin practicing and seeing patients and having to go through the potential of having to shut the practice down, advise the patients that you have to move on, um, it is not a very appealing process for most people. So, um, you'd want to try and go through this stepwise approach before running off and getting a lawyer to file an action in court. And that's all I have. I hope you found this helpful. I'll be available for some questions that you can submit through the portal. I have one question that was asked earlier. It says, do these same rules apply in New York City? And the answer is that New York follows a similar approach to New Jersey, but the case law is not exactly the same. Generally, New York, and I am licensed in both New York and New Jersey. New York courts are not don't as heavily favor or provide a presumption that the contract is enforceable and favor the employer. New York does blue pencil, but um, but it has a number of different kind of twists and turns, but it's substantially similar. Um, Substantially similar to New Jersey in that it will try and reform the contract. There's another question here, is that would it be better to try to talk to the employer prior to the attorney? The answer there is that it's always going to depend on what the relationship is among the parties. And that is really a case by case basis. Generally, going in or at the front end of a contract, I very often advise clients to speak directly, to their potential employer, rather than just inserting the attorney immediately. In this case, on the back end, it's a little bit different. I would always recommend that you speak to an attorney first. You can always you control the attorney, so the approach that I would suggest is that you consult with an attorney, have them go through the contract, and then you can say to the attorney, look, I don't want you to speak to anybody. I don't want you calling the employer. I don't want you speaking to the employer's attorney. I would like to, make the first communication myself, armed with the information that you've provided. Now, I wouldn't recommend that you go and sit down with the lawyer and then go just recite a bunch of legal principles to the employer. It would be more along the lines of something like, look, I've decided to move on. I want to go into private practice on my own, and I want to stay in this area. I understand they have a restrictive covenant, um, but I don't think it's reasonable. I don't think it's, enforceable, and I don't think it's really in the best interest of the patients. So, is there some middle ground? Can we work on something um, and get a sense uh, of the posture of the employer? I can tell you that there are some, there are some hospitals in New York City, or there's one in particular that I know that that they don't enforce non-competes. Their attorneys have told me, look, our position is if a physician doesn't want to be here anymore, then we don't want them here, and they can go, and we're not going to try and keep them from practicing. We maintain our institution on its own merits. And that's, we rather have doctors that are happy to be here than ones that are chained here because of a contract. So it is a good idea to, potentially feel out and get a sense of where you are. I have another question I'm trying to open. For some reason I can't see this entire question. There's a question asking about, I think, securing privileges elsewhere, but it got cut off. You could resend that question. Be happy to answer
Hello,
it.
John. Hi, I can read that question out for you.
Okay.
The question is if a hospital terminates you without disciplinary procedure, can they block you from getting privileges elsewhere?
Sure. So the question of whether a hospital that has I'm assuming has a restrictive covenant, and terminates your privileges, can they block it at another hospital, from getting privileges at another hospital? And you can. There is something, and I didn't mention it because I didn't want to get too deep into the weeds with enforcement of restrictive covenants. But there is another cause of action that an employer can take, which is known as interference with a contractual relationship. And what one hospital can do is let's say hypothetically a physician had a agreement with one hospital that they wouldn't go and work at any other hospital, and the physician leaves, and hospital A revokes their medical staff privileges pursuant to this contract. Now that physician goes to hospital B and applies for privileges. Now the hospital B, what they should be doing is that asking whether they have any restrictions. And if the hospital B attempts to hire that physician or provide them privileges, hospital A could go to court and seek injunctive relief to stop that hospital from giving privileges to that physician. So, but the hospital B would have to be put on notice that there is a restrictive covenant. So it is possible. Okay, so I think I don't see any other questions. So I thank you all for your time. I hope you enjoyed the webinar, and you all have a great day. Thank you for listening. Bye-bye.